Hello, good night. This is U.S. Immigration Attorney Sharifa Tharp. I'm here live to take your U.S. immigration related questions. Go ahead and put your questions in the comments now. I am a U.S. immigration attorney, managing attorney at ST Law Office. We are based in Delray Beach, Florida. However, we represent clients in all 50 states and the globe. And I'm here today to just focus on questions. So I'm going to spend the next half an hour just focusing on your questions. So put your questions in the comments now so that I can see those questions. Hi there, Poonam, it's nice to see you. And put those questions in the comments. Happy Friday. I hope you're looking forward to a restful weekend. Now, there's a lot going on in immigration right now. And I think for the most part, in the past week, I've updated you on those, what the some major changes are. But what I would like to say is one common theme, and you're going to hear this from other immigration attorneys, is the climate is not one to navigate on your own. The way that they are designing this process is they're adding an uh, an element of complexity in that you can't just fill out documents and submit it. For example, citizenship. It's not a situation now where you can just fill it out, check the boxes, and expect to get citizenship. Now there is more to it than that. Now you do have to provide evidence, solid evidence of good moral character, which is going to be a lot more subjective. I When I think about it, I think about where you're applying to, applying to college, right? Where you have to put together your letters of recommendations, your personal statement detailing why you should be admitted to that university. I would say that based on the what they're going to be looking at in order to determine whether they're going to grant citizenship, it looks very much like that. Like you're going to have to show how is it, what have you been doing here as a green card holder? What are the positives that warrants approval of your citizenship application? So don't go that process alone. Give us a call. We are good at this. I would say that's a strength of ours. So go ahead, give us a call. Let's talk and get started. And this goes for any and all immigration processes. One misstep, the way, and this is in the policy manual. And you have to be an experienced immigration attorney to understand the implications of these policies. When I read it, and when other attorneys read it as well, we realize very quickly what's happening. So when I read the policy manual and read the changes, what they're doing is they're basically saying they can deny your application, and if they do, they're sending a notice to appear right away. They're not giving any, they have the right not to give second chances. That means that they won't notify you that you made a slight mistake or that you forgot to file a document. They will just deny it. And then guess what? When they deny it, they deny you the ability to get protection. They quickly issue a notice to appear. And once you get a notice to appear, you can't just reapply. Now you're in the hands of the court and the process gets more expensive. So anybody who does not know the procedural requirements, the documentary requirements, they're just kind of feeling their way through the process, you are at serious risk for complications in your case. So make sure that you're doing it right the first time because you may not be able to get a second chance the way that they're designing the policies. All right, so now I see questions coming in. So I'm going to answer your questions today. I am going from platform to platform. I'm going to start on Instagram and then move from there. Hello, is there any status to switch to Haiti TPS is about to be over, yes, we can evaluate you for other options. Absolutely. If you're losing parole, losing TPS, know that there are other options. We just need to talk to you and figure out if you fall under one of those options. But that is absolutely possible. And that's what I would say here is focus your energy on other options. And that's what we do here. What's the best process to go about to get legally? If I got here on a transit visa, I don't want to be a citizen, but I'd like to travel back and forth. I do have children in the States. So the transit visa can be difficult because of restrictions on adjustment of status. So you definitely need to talk to us. We need to figure out what have you been through, what caused you to overstay that transit visa, and then we would be able to look at other options. So we have a number of options that we look at. This is it's not a one size fits all, and you need to make sure you get personalized legal advice and an evaluation of your options. We can definitely do that in an appointment. So click on the link and schedule your appointment. You can schedule it yourself, or you can call the office and get help with setting an appointment. My VAWA got approved and I submitted medical for I-485, but never hear anything since 10 months ago. That's not out of the ordinary. That is happening. I would say it could be even up to a year. Keep in mind, I can't guarantee timelines either. I'm doing it based on my own experience, but it's not out of the ordinary, especially now that we've changed administrations. They're slowing down a bit on some applications. I like to know what was the update of a citizen to our brothers in Mexico. So you would have to look at the national visa bulletin, and that will tell you your category, and then which is F4 category, and then you would look at your date on your I-130 and what's the date that's showing there. If your date shows up before the date on the table, then they could be ready to start processing your application. If an employee is withdrawn from H1 CAP, does he or she have time to find employment within 60 days, or is it instant dismissal to home country? It helps many. So there is, make sure in this case, if you have been terminated or withdrawn, it's time to definitely, so you said withdrawn from the H1 cap. So this is where you need to evaluate your options and see if you do have a timeline to be able to find another job. Usually there is that grace period, but we want to evaluate what's going on in your case to determine whether that applies to you. From West Africa, got 5-year visa from 2022. Will it still be valid? Your visa, no. If you're from a barred country, it does not affect existing visa holders. You just said West Africa, so I don't know which country you're from in West Africa, but that visa should still be valid. The ban should not affect existing visa holders. Now, if you went to renew, that may be the issue. So I just sent my case for AOS. I sent my case to AZ via FedEx, but the address on my. So when it comes to specifics like this, that's out of my hands because the instructions are very specific. So I can't advise on logistics. It just depends on a number of factors regarding your case as to where it was sent. So you definitely need to talk to your attorney at that point. How long does it take to get an interview date in Nigeria? So I'd say prepare for a 2-year wait period. Yeah, it is taking a while. All right. I have I-485 filed for my kids and I with a joint sponsor, but my husband got a federal case in March 2025. How will it affect my case? It depends on what the criminal offense was. Now, it is in the policy manual that if your spouse is in the jail at the time of the interview, there may be a way to request either telephonic appearance or to waive the appearance of the spouse. So that may still be possible to move forward. Now, it also, whether or not your case moves forward in the right direction depends on what they were convicted for. Did it involve a minor? Under the Adam Walsh Act, if it involved a minor, you may have a problem with your spouse being the petitioner. He may not be allowed to proceed. So it just depends. Okay, so bank fraud, as long as it didn't include a minor. So the Adam Walsh Act is the only act that really bars a petitioner from moving forward in the process. So if it's bank fraud, it shouldn't be a problem. But keep in mind, I'm not your attorney. Can't give you personalized legal advice. You need to make sure you are talking to your attorney or you're getting an attorney. Can you still get your papers in the US if you've been charged with a non-violent felony? Even non-violent felonies now are being closer scrutinized. So it just depends on what the felony is. One thing you should never do is try to oversimplify the consequences of an offense, especially now. So make sure that once there's an offense in place, before you even apply, you understand exactly what that offense is going to do. How is it going to affect you? Does it disqualify you? Or going forward, can you apply for forgiveness? Applying with a non-violent felony, nonviolent does not mean that you're not deportable. So it's so important to get it evaluated, especially if it's at the point of a felony. But keep in mind, even misdemeanors can render you deportable, depending on the misdemeanor. So um, just make sure when it comes to criminal offenses, we can't just give an answer on the spot. Maybe we'll have a clue, an idea, but when it comes to offenses, we better be sure what the consequences would be and what's needed to remedy the situation. So definitely make sure you get your attorney. Can you apply for citizenship when your marriage is almost 3 years and your green card almost 2 years instead of applying for 10 years? Or it's better to apply for 10 years. Now, here's the deal: you cannot skip the step of applying, going from the 2 year to the 10 year. You must apply to remove the conditions to get your 10 year. So you can't skip that step. Actually, in the early part of the administration, that's exactly what a spouse did. And it hit the news. He was in a detention because he forgot to go for his 10 year by removing the conditions. So he lost his papers, probably it was referred to court, and they rendered him deportable without him even knowing all of that happened to him. So you must apply to remove the conditions. We do that. So get in touch with us so we can help you with it. Now, citizenship, at the point that you do qualify, you have to have your green card for 3 years. You have to be married and living in marital union for at least 3 years to a US citizen to be able to qualify for the shorter timeline of 3 years to get citizenship. So in that case, you need to make sure that you at that point, you need to make sure you qualify based on that criteria, along with other things: good moral character, continuous presence, physical presence in the United States. Now, identity theft, you need to talk to us. What we do is we evaluate. So we do an in-depth analysis of the offense. We are able to advise you on how to move forward from there. Because identity theft is very general. What were the facts? We have to look at the state law. We have to look at the facts. Identity theft is telling me there was a victim involved. So what was the damage to the victim, how much was what did the fraud take out of the victim's pocket. That counts towards determining whether that it amounts to a deportable offense, even maybe an aggravated felony. So you want to don't skip the step of just applying for something. Make sure you're understanding fully what the implications are with that. I have a F2 visa. I have a baby here. Can I convert my visa to work? Uh, it depends. You're on F2 if you qualify for work. Like, for example, you qualify for H1B. The employer wants to help petition for the H1B, then that could potentially be an option for you. So it just depends on what do you qualify for, though, because the H1B depends. You have to have certain qualifications, a certain level of education in some cases. So keep that in mind. All right. So now I'm going to go over to YouTube and Facebook. Go ahead and put your questions in the comments. Now I see a couple questions already. I'm going to start at the top. How long is it taking to get receipt notices for T visa? And are they still giving bona fide determinations? Yes, bona fide determinations are still, the process is still moving forward, guys. It's just that what the process, they're a lot more strict, right? So you get something wrong in the process, that's where things can change. Also, they're asking more questions. They're digging. They're adding additional criteria, additional screenings. So anti-American screening. They're looking at. They have talked about social media screening. So these are some additional steps and processes and criteria they're adding, but the processes are moving forward because it's written in the law, and until Congress erases it from the law, they have to process these. So if you qualify, go for it, but make sure you're doing it correctly. Hello, Marcia. Happy Friday. It's nice to see you. Hi, Karen. Hi, Dwayne. Nice to see you. Happy Friday. I'm from the F1 category. My mother's a US citizen and I'm over the age of 21. My priority date is 22 July 2016. When will I be current to get an interview? I'd have to really look at the National Visa Bulletin. But what I would say is that process, based on the criteria you gave me, is about 5 to 7 years long. So you should be getting something going. Now, if your priority date, it sounds like, did they give you an okay to say you're documentarily qualified? If they are, then now you're in the waiting period for the interview. It's taking about a year and a half to 2 years to wait for an interview, believe it or not. So right when you think you have all the papers in, oh my God, it's interview time, it hits you across the face after you've been waiting 6 months, and 6 months turn to 8 months, and then 8 months turn to 12 months, and you're like, I thought I was at the end of the process. What's going on? Thank you so much for the gifts and the love on TikTok. I really appreciate that. Hit the screen. I'm gonna come on to TikTok very soon. I'm going from platform to platform. TikTok is next. Put your questions in the comments, tap the screen so others can see information that's going to empower them in their immigration journey right now. Thank you so much. Thanks for sharing the live. Thank you for your gifts and your loves. I appreciate it. I overstayed my visitor's visa for 4 years, got married to a US citizen, and adjusted my status, received my conditional green card. Can I travel and re enter the US? No criminal record. Now, what I say here is do not take any actions outside of getting help when I'm speaking, but I'm here to give you general information that can put you in the right direction. What I would say here is green card holders can travel. Yes, even if you have conditional green card. If you have the conditional green card, You have to make sure that you followed all the right steps to submit your removal of conditions. If it's time to apply, make sure that you have your extension letter if you are already applying. Make sure you have your original extension letter, as in no copies. You have the original letter, as well as the expired 2-year green card and your passport. So, and just make sure there's nothing new in your background that's gonna cause any issues, like any new arrests or anything that they don't know about. I filed the I-130. Do I have to wait for approval before I file I-485? Be very careful with this. That's where the risk goes up for a notice to appear. If you've overstayed, if you're here, you've overstayed, and you file an I-130 petition without an adjustment of status, that's where they can find the space to send a notice to appear. They can approve it. Yay, you're approved. And here you go. We also see, based on the I-130, we see an I-130 petition. Great. You look like you qualify. But we don't see that adjustment of status application. And we notice you're here in the US. And we also notice you've overstayed. So guess what? No adjustment of status, which means we can't process an green card for you here in the US. That must mean that you're deportable, right? So because there's no protection for the adjustment of status. So you need to understand, at what point do you file the I-485? What are the risks of just filing an I-130 petition? Do you qualify for an I-485 to begin with? So get in touch with us and hire an attorney, invest in that, because not investing from the get-go means it's going to get a lot more expensive, and sometimes money can't even fix the damage later on. Hi, with VAWA, a 10-year green card, how long can you wait before filing for citizenship? So if you are married to a US citizen, you got VAWA 3 years. Anybody else, 5 years. Can I go to biometrics appointment with expired passport? So I'm not your attorney. I can't give you a particular, I can't tell you what to do, but my clients, when they have, that was the last resort, that was okay. The last I heard that happening was under Biden last year. So we have not tested that since this new administration. And I do know back in, between 2016 and 2020, when I did practice under the Trump administration, they did not allow people to go into the buildings with expired passports. And so we had one client that did not have a current passport, and we had to find all sorts of alternatives. We had to talk to USCIS, find out what they would accept, and then move forward with the instructions on what else to provide. So, that's where it depends on their policies they have now. All right, so now I'm on TikTok. Hello, everybody. Thanks again for the love. Asylum decision pending after interview since September 2021. Sent request, but nothing progress. Wow, that's a long time. And it sometimes there's just no rhyme or reason. Sometimes your case may be going through extra security checks. So it just depends. That's a situation where you definitely have to talk to us or talk to an attorney to figure out what could be the next steps to move forward. What are your circumstances that you're facing that may be causing hardships as a result of the delay? My mom applied for me I-130 2015. She's a US citizen. I'm married, daughter. How long more will it take? So just count about 12 years from the date, your priority date. What about cases of I-730 filed in 2022, Sudan? So I'd have to look at the processing times for those right now. But yeah, those can take years, especially if they're waiting for security clearances and interviews. I-134 form, do I need to bring it in the day of my interview or fill it online for my K visa. So that is for the petitioner, and yeah, it should be. So usually, when you're going through the visa process, they ask for that to be uploaded, and then make sure you're bringing it with you to the interview in case of anything. How long will VAWA take to get a response appointment? So a biometrics appointment, so right now it's taking 3 months to get the receipt notice and then another 2 months to get biometrics. So about 5 months after filing. Is it possible for an immigration attorney to speed up a filing case? In some cases, yes, that's a possibility if it's the right case. Keep in mind that if from the get go, before you even file anything, the attorney is saying they can pull some strings to get your case moved along faster, they're not being honest. And they are sort of acting scamish. So if that's the case, no lawyer can make the process move faster. However, in the case your case has been processing for a while and there are some issues with that, there are some ways to be able to see how to speed that up, that process up. How long are bona fides for U visas taking? About 2 years, a year and a half to 2 years. How are bonds paid over time? So you have to post the bond at the time that is issued, and I don't believe it's over time, but you can work with bonds people or bail bonds. I think they call them. They have immigration ones as well that can help provide the bond payment, and then you would have the arrangement with them. So there are immigration ones as well. So you can Google and find some reputable ones. Um, Now, for our fees, we are based on flat fees, so we don't do hourly, and we also have payment plans available. So you can get once we do determine you qualify, and we understand your case and what it's gonna take. The next step is we focus on what payment plan could work for you. I used to live in the US. Now I'm currently in Mexico. Can my husband still petition for me? It depends. Depends on what happened when you were leaving the U.S. Was there a permanent bar that you had? It's possible, but we'd have to understand what the circumstances are and whether that stops your spouse from petitioning for you. So get in touch with us. That's why we're here. We're here to guide you through those complexities. VAWA approved an RFE I-601 for green card. How long will I-601 take for decision? About 2 years, unfortunately. Been approved from judge and waiting for 4 years. How long will it take? And is it what for what? Exactly. Was it cancellation of removal? Thank you for sharing the live. How long are T visa applications to get a response? You're looking at about 4 months just to get the receipt notice, and then about 2 months for biometrics, then another 3 months for the bona fide determination that does provide a protection, and then another 4 months for the work permit. Now, a lot of people may say, "Oh my gosh, that's gonna take so long." Mind you, they don't have any other options, but they're saying, "No, that's going to take so long. I'm not going to go for it." What you may be doing in that instant is you're basically selling yourself short, because you're saying that because you can't get this thing right now, you're not going to go ahead and make a move to protect yourself. So you lose in the short term, because in the short term you face more risk. You go out there every single day, and while you're going to work, you could be stopped by police, and they could ask you for your papers. If you don't have anything to go off of at all, your defenses and your ability to protect yourself goes down substantially. So, what I have noticed is we have had clients who were detained, but because they had a pending process, we were able to show strong evidence of that and that they qualified. The judge considered that and released them. Now, once you go into a situation like that, it's very hard to establish anything at that point. And let me tell you, communication is almost next to none, right? Nobody's listening to you. People are reduced to being A numbers, right? Meaning they don't really care about anybody's story when they're there. And if they don't have somebody out there speaking for them, it gets very hard. To fix the situation. So one thing I can say is it's your choice whether you're going to decide to move forward with a process that could potentially give you options. And when we work with our clients, we don't just pick any cases. We make sure that they have a real shot to get this, right? We don't just tell everybody they qualify. In some cases we have to look, we in the best interest of the individual, we let them know, well, in this case you don't qualify, right? But in the case you do qualify, and that's where you need to make sure you're checking what your options are. We're telling you you qualify because we have seen success there. We know what looks like a winning case, and we are willing to fight for you. In the case that you choose to continue to be undocumented, you don't have anything to go off of, right? And everybody is at that risk right now. Everybody is facing a risk. If you apply for marriage base, if you are applying for work base, everybody's facing that very scary risk. So it's you're not the only one that's facing it, and it's basically a part of the reality of applying for what you qualify for. So keep that in mind. Don't sell yourself short. Do not put yourself in harm's way by making the wrong decision. I am in a travel ban. Can I travel with green card? If you're a green card holder, you aren't exempt. You will not be affected by the travel ban. My I-94 will expire in September 19, and I will be getting married September 10th. Can I file for AOS immediately? Get in touch with us. I cannot tell you specifically whether it's advisable to apply right away, because that wouldn't be prudent of me. I need to understand first, because now we're looking at making sure everything is done precisely, make sure everything is done correctly. So get in touch with us. What I will say is once you get married, you can file. If you're the spouse of a US citizen, that I-94 expiring is not based on the law, will not stop you from qualifying. Being a spouse of a US citizen means the overstay does not affect you. And yes, that is still the law. But if you don't do it correctly and you overstay, that's where they can come in and say, oh, you made a mistake. We had to deny or reject. So here's your notice to appear now because you're overstayed and you didn't file it correctly. So that's where I'm seeing the harm, where a lot of the harm is going to be. Can a green card holder claim citizenship if their parent was naturalized when they were under 18? Do not claim citizenship unless until you verify you're a US citizen, because it's one of the worst things that you can do. So be very careful. Make sure you confirm you are a US citizen. If you are a green card holder, your parent became a US citizen while you are a green card holder in the United States under 18, it's very likely that you became a US citizen at the same time your parents did. And it's a matter of applying for your passport or your N600 to be able to show proof that you're a citizen. But if, say, you were in another country or you didn't have your papers at the time that your parent became a US citizen, it would be treated differently. And we'd have to just look at your facts to determine, because there are multiple ways that you may derive citizenship from a parent, and I have to understand fully, where do you fall. VAWA submitted last May. How much longer to approval EAD and prima facie received? So I would say count at least 3.5 years from the time you filed the I-360. But the USCIS denied my case because my status is temporarily expired. So this is what I'm talking about. A lot of people get confused about this, and this is where mistakes happen. Not everybody who applies for adjustment of status qualifies for adjustment of status. And in your case, you probably are in a category where you can't overstay. Some people can end up overstaying and still be okay. Some people can't. So it's very important to understand. And if the officer denied you because of an overstay and you are the immediate relative of a US citizen, then there's some mistake there, right? That can be fixed. But this is where I say, guys, get it right from the start. And these are the things that experienced immigration attorneys do. Those are the things we do. Is we can look at your category and say, okay, you don't qualify for adjustment of status because you've overstayed, and you're in a category where when you overstay, you don't qualify for adjustment of status. So, for example, if you're the son or daughter of a US citizen, 21 or older, you overstayed, if you didn't apply before your time expired and your priority date is not current, that's going to be a serious problem. And that's a mistake a lot of people make. And out of fear and desperation to find anything, a lot of people are going to make that mistake, but it actually increases their chance of getting a notice to appear, because just applying out of desperation and not understanding the implications of that application is where a lot of people are going to make mistakes. So do it right. And if you are the immediate relative of a U.S. citizen, you got the right type of parole, then there's something that may be wrong. So this is where I say an individual appointment is essential to understand your facts. We need to ask additional questions, the questions that we know to ask, to be able to come to a conclusion and advise you on what the solution could be. I left the US on my own, also have no criminal background. And that's a choice, definitely a choice you're entitled to. I have a conditional green card. I got it last November. Oh boy, where is it? Okay. So I got it last November. Is it safe to go back to the Philippines? Having a conditional green card enables you to travel in and out of the country. You just can't be traveling out and staying out for more than 6 months. And you must make sure you don't have anything specific in your background that's going to cause complications coming back into the country. So, green card holders, you can travel, but keep in mind that the risk is higher because of the way that they are screening. So you want to make sure you do your due diligence before leaving. For example, in the past week, we saw a green card holder wife who was coming back from vacation. She was detained at the airport, and that's because she had a conviction 20 years ago for marijuana. And because before she left, she did not fully vet what that meant for her. Because had she maybe spoken to her immigration attorney or a good experienced immigration attorney, they would have been able to say, okay, you have this on your record, that could be a problem, especially if it was never disclosed before. So that's where, you as a green card holder, you have to be careful. Can a green card holder claim citizenship if their parent was not? So I answered that. Let's see. Does having non-active tuberculosis cause immigrant visa denial? So I no, I'm not with non-active. I don't know if that is, you need to talk to the doctor about it, because there are situations where if you've had the tuberculosis vaccine, then you would have to, like, for example, in Jamaica, I believe I got the tuberculosis vaccine. And because of that, you couldn't do the test because, or a certain test, because it may still show, because of the antibodies, it still shows there's some kind of tuberculosis, but it's not. It's just basically because of the vaccine. So they have to do an x ray to show that there's no tuberculosis. So I don't know if that's what you're referring to, or so you have it, or it's just dormant in your body. To talk to the doctor and just, or talk to the doctor and find out if that could be a problem for your application, because I'm I'm not very familiar with that, with the effect of that. I have the same question. Does age matter as well? So age, yes, age will matter. So it's on their red flags. It's on their list of red flags. If they see a large age gap, they're going to start asking more questions to make sure it's not a fraudulent marriage. I left the country on my own. I also have no criminal background. If you left the country on your own, keep in mind, if you were here for more than 6 months without your papers, that's a 3-year bar. If you were here in the country and you overstayed your time or you entered the country without permission and then left, you're looking at 10-year bar. So your spouse may be able to petition for you, but there's definitely going to be a lot more that goes into it to get you back into the country. So it might take some time. You'd have to apply depending on your facts. I don't know if it's this, but uh, the, based on what I said, if you do have a 10-year bar and you want to come back to the country before the 10-year bar, you have to apply for permission to reapply for re-entry. Then you probably have to apply for a waiver, an I-601 waiver for unlawful presence. And then once they approve those, they would then allow the approval of the petition to move forward. So it may be possible. H-2B visa expires in 7 days. Can I switch to B2 while I search for a new sponsor? So that is a very tricky question, because you can't just sit here and you can certainly apply to go change your status, but you said in 7 days. You're actually supposed to apply around 90 days before your time expires to give enough time for a decision. So I would say doing that right now is very risky, and I can't tell you what to do. But if you don't want to overstay, of course, you would have to go out of the country and then re-enter on B2. Now that could raise red flags though, because they might ask, are you trying to live here? So you left on the H2B and trying to come back on a B2, that's a huge red flag. So make sure you are you're in your situation, an attorney is directly advising you. My dad needs to file an I-601 for misrepresentation. He overstayed 25 years ago. Yes. Also, I have 1-year-old child and have been in the US over 20 years. So keep in mind, one thing I want to let you know too, because I want to approach everything from the perspective of being solution oriented. That's how we are pushing, and that's how we continue to change lives, even in this climate. But what I would say here, guys, is just know that all along the immigration journey, even if you do find yourself detained, there are ways to be able to defend yourself. But if you don't approach it smartly and in an informed way, you could lose at that too. So make sure you're informed about your options before something like that happens. For example, we did have a situation where we clearly identified that someone qualified for relief and we were ready to go, but they declined, and now they're in detention, right? And it's very hard because now they're detained, communication gets very hard. Now it's not just about applying for this benefit, now it's about doing a deportation defense. So, now it's a lot harder for this person to be able to resolve the issue, right? And it's hard to communicate with us now because they're detained. So keep that in mind, that just having a plan, understanding your options before anything like that happens, and taking action is essential. All right, that's gonna be it for me. Let me see here. If husband deny his children when his wife is filing for his papers to come to the US, can he still file the papers for his children? Get legal advice. Something sounds very convoluted here, so we need to understand fully what, because it sounds like here husband didn't put children on the application, and now he wants this petition for his kids. He now has to say he has children. That's a huge problem. And while I don't want to come to any conclusions, that's where we need to talk to you, to understand the intention, to fully understand what happened. That can be a big problem. What if you're here on a visitor's visa and you would like to apply for a working visa? Is that possible? It may be possible, but keep in mind that it depends on how long each process will take and whether you're able to stay the amount of time, maintain your visa while you're applying for that. Is the same denial of EAD renewal if it was denied for false claim versus denial for not responding to an RFE. So we'd have to understand your situation. It could have been both. Maybe you were supposed to respond to an RFE, but if they denied your EAD renewal and you didn't respond to that RFE, then they're probably getting ready to deny the whole thing. All right, guys, I'm gonna head out. So if been abuser by my spouse before the interview I-45, I don't mention nothing to USIS on my I-751. It's safe to waiver my husband based on abuse. Yes, give us a call. That's exactly what we work with our clients. But absolutely, because the focus of the interview is not to talk about the abuse to get the green card, but you do have the freedom when you're going from the 2 year to the 10 year to raise this and to be able to apply on your own. Give us a call. Let's talk and get started. Thanks again, everybody, for your time. I really appreciate it. These are all great questions. I will see you on Monday. I hope you have a productive, restful weekend, and I will see you on Monday. So stay engaged. I continue to post videos every single day, giving you information. So like, share, subscribe, follow, hit the notification bell. You'll see when I come on, and you'll also help others to see information that empowers them through their immigration journey. Also, know, guys, that we're here to help. We're a safe space. It's confidential when you talk to us, and you'll be making a move to potentially find an option for your situation. All right, have a good night. Bye bye.